Sure. Hi everyone, my name is Lynn. I'm the Director of Student Life and Engagement here at the school line. So obviously thank you for coming to class this morning. And thank you, Dr. Dreyer, for allowing us to have our annual Constitution Day speaker as part of this class. So I'm going to introduce our speaker today, and then there'll be some time at the very end to ask some questions. So Wipf Pfeifle is a circuit court judge from the Seventh Judicial Circuit. She was appointed by Governor Dennis Daugaard in 2015. Prior to her appointment, she was a shareholder with Lynn, Jackson, Shultz, and Lebrun, PC, in the Rapid City office. She was associated with the firm for nearly 30 years after completing a clerkship in the Federal District Court following graduation from the University of South Dakota School of Law in 1984. She also served as part-time Associate Justice with the Oglala Sioux Nation Supreme Court. She's married to Craig Pfeifle, the Presiding Judge of the Seventh Judicial Circuit, and they have 4 children and 2 grandchildren. Please join me in welcoming Judge Pfeifle.
Thank you. Can everybody hear me all right? All right. If you have any questions while I'm speaking, just raise your hand and I'll be happy to answer those. When I'm speaking, of course, I'm generally in the courtroom and then I'm always in charge. And so, and nobody except the lawyers get to talk to me, so or the defendant, so you get a chance to ask me any kind of questions. Yesterday was actual Constitution Day, recognized all over the United States. The Constitution is 232 years old. It is the world's longest Constitution still in use, the oldest one, and it's the briefest, really. And so when the Founding Fathers got together to create the Constitution, rather than having a really detailed recipe, for lack of a better word, they had these broad principles that came into being. And because of that, it has stood the test of time. As you know, it's been amended quite a number of times. The initial 7 articles established separation of powers, a number of clauses about full faith and credit, the Supremacy Clause, and then the first 10 amendments are called the Bill of Rights. And that's part of the Bill of Rights, what I'm going to talk to you about today. Dr. Dreyer suggested that it might be of interest to you to know how the Constitution plays out in my job. You can imagine the Constitution is the backdrop for many, many things that I do throughout the day. As a circuit court judge, we are called judges of general jurisdiction. And so that means we have a broad type of jurisdiction, which is power of the court. And so I will hear everything from criminal matters, felonies on up, and I'm sure you know a felony is an offense that could be punished by a prison sentence. You may also serve jail time, but the ultimate penalty would result in a prison sentence. Then I handle marriage, adoption, child support matters, car accidents, contract matters, any type of civil case. The only thing I typically do not handle are small claims actions, those go before a magistrate, and misdemeanors, which would be a term served in jail. Now, if someone's charged with a felony and a misdemeanor, they will both come to me. So it isn't that I never see a misdemeanor, but that's really what it means about to be a judge of general jurisdiction. Every Thursday is what is called short cause day for me, and every judge has one. And on that short cause day, in the morning I'll hear civil matters, and in the afternoon I hear criminal matters. And I start at 1:30 and I go straight through till 5:30 or 6. And sometimes I will have as many as 50 hearings during that time. That seems like an extraordinary number. Some are simply very quick scheduling hearings. But the first thing I do is called arraignments. So someone charged with a felony is going to come before me. That person has already been before the magistrate. They're entitled to have an appearance right away where they're read their rights, but at that hearing they cannot plead guilty. They're charged with a felony. That magistrate likely has appointed a lawyer for them and set bond. That is if they're in custody. So they come before me, and this, what I have to do that I'm required by law is to go over their rights again. And it's important because people are nervous when they're in court generally. And I had this experience when I was a very young lawyer. I represented a fellow in a federal court, and he was charged with assaulting a park ranger. And at the time of sentencing, the judge gave his sentence, and he asked my client, I'm standing right next to him, asked him all sorts of questions. You know, you've been satisfied with your lawyer, do you understand your sentence? You know, lots of questions. And my client answered all of them, and the judge sentenced him, and the minute it was done, the client turned to me and said, what did he say? And it was such a good lesson for me that people who indicate they're listening, and they know you're asking them something, but they don't always know what you're saying. So anyway, that's why we go over it again. So the first one that we tell them about is an important right under the Sixth Amendment, your right to have a lawyer. If you can't afford a lawyer, one will be appointed for you. Now, in South Dakota, in state court, that means I will appoint a lawyer for you, but you are ultimately responsible for those fees. So the county will pay them up front, but you will be responsible. You'll have to pay them back, or the county will have a lien against your property. That isn't the law in federal court, and it isn't the law in every state, but it's a very important one. Sometimes people do get to me without having a lawyer, and I then appoint one at that arraignment. Many times people have multiple charges, and they already have a lawyer, and I will just simply appoint them on that case. You also have a constitutional right to represent yourself. And I currently have a fellow charged with murder in front of me that has decided he wants to represent himself, and a fellow charged with rape and kidnapping that has decided he wants to represent himself. So I'm required to go through a very specific list of questions to make sure they understand it. For example, I'm required to ask them, do you understand that you can't later complain about ineffective assistance of counsel if you're convicted? You understand the state is going to be represented by a very experienced lawyer who could take advantage of you fairly because you don't understand the rules. You understand that there are certain rules that apply in the way we put evidence in and procedures, and that I can't help you. Because my job isn't to help, my job is the referee. And so case law has addressed this, and once I'm satisfied that they understand what the risks are, then I'll allow them to proceed to represent themselves. I typically, and in the cases I've just described to you, I appoint what's called standby counsel. And that lawyer's job is to stand by. And so if defendant doesn't know how to do something, especially during the trial, they can turn to the lawyer and ask for help. But the defendant runs the whole, the defendant is in charge of all decisions, all strategy, how we're going to go ahead. Sometimes during the course of the trial, they turn it over to the standby counsel. But it is a very important right that you could represent yourself. The next right I advise them of is you have the right to be present at all stages of the proceedings against you. And while that sentence doesn't appear in our Constitution, it's implied in the Sixth Amendment, your right to be informed of the nature and the cause of the accusation, your right to defend in person. You need to be present in person or by your lawyer, and of course the Fifth Amendment due process rights. I advise them that they have been charged by either information or indictment, and so they are entitled to see and know the charges against them. They get a piece of paper that if it was indictment, do you know how an indictment comes down? By grand jury. And Pennington County has a grand jury. I also, because we're at the Seventh Circuit, our jurisdiction is through Custer County, Fall River County, Oglala, Dakota County, and Pennington County. I am also assigned to be the judge in Custer County. These assignments last for 18 months, and my previous assignment was Fall River and Oglala, Dakota County. So those Fall River and Oglala, Dakota do not typically have a grand jury. If they want to have one, they need to get permission from the presiding judge to have one. The Custer County just had one yesterday. And these are people that are called in. I just, in Custer County, I did just assist in getting the grand jury. At least 6 people have to, there's a certain number that meets, 6 to 10. At least 6 people charges presented by the prosecutor. The prosecutor puts on a very, very basic case. And if those 6 people agree on the charges, then someone can be charged by indictment. The prosecutor could also decide to charge by information. And so a little process has to happen before that. But so they come in, the prosecutor reads the indictment or the information to them. I ensure that they understand what they're being charged with, and then I'm required to go over whatever the penalties are that they could face. So I tell them they have a right to confront and cross-examine any witnesses presented against them. This right of cross-examination is perhaps, most lawyers, I think, and judges would agree, that it's the most important right available to a defendant. And it's your right. So important is this right of cross-examination. Sometimes the Supreme Court has referred to it as people being tested in the crucible of cross-examination, and it's the best method to determine what the truth is. And it isn't always that people are lying. They're mixed up. They don't understand the timeline. They have conflated 2 events. And so we had a pretty interesting change in the law a number of years ago, and I would invite you to read this case. You can just Google it. You can find it on Google Scholar. It's called Washington versus Crawford. If you like history at all, or you just have absolutely nothing better to do, read this case. But Michael Crawford was charged with stabbing a man that he claimed tried to rape his wife. And so during the trial, the prosecution, the state, played a video audio of his wife and what she said. The reason they did that is because after the stabbing, he's brought in, wife is brought in, they're put in separate rooms. She gives a statement. Of course, you should know that anytime you're in the police station or talking to law enforcement, you're likely being recorded. And so whether she knew it or not doesn't really matter. But Washington has what's called a spousal privilege or a marital privilege. And so if he did not agree, because he's married to her, she couldn't testify. So the prosecution said, well, there she was. We took a statement, and so we're going to play that at trial. Well, the case went all the way up to the United States Supreme Court, and a fellow heard about it, a lawyer in Seattle heard about it, when he saw that the Washington Supreme Court had denied his appeal, saying that it wasn't a violation of his Confrontation Clause rights, that there was some indicia of reliability. So he contacted that guy's lawyer and said, I'd like to take this to see if we can go to the Supreme Court with this. And the lawyer said yes, and this has become a landmark case. And so what Crawford then says is, if you're playing out-of-court testimony to a jury with no chance of cross-examination, so keep in mind, the defendant and his lawyer could not cross-examine the wife, right? Because it was only her statement. And you know what I mean by cross-examination? Have I jumped over? That's questioning. It's direct questioning of the person. You're on the stand testifying, you've told me a story, I'm the defense attorney, I have the right to quiz you over and over about what you said. It's an art and a skill of cross-examination. So the Supreme Court said that it is a violation, that you have the right to, the Sixth Amendment says you have the right to confront and cross-examine. So it isn't enough simply to have someone come in and read a statement, because the defendant cannot test the veracity, the truthfulness of that statement. It is really the primary mechanism for testing these out-of-court statements. And Justice Scalia wrote the opinion. He is a very interesting, colorful writer. And he went all the way back to the trial of Sir Walter Raleigh back in 1600s. So think of this, more than 400 years later, he's taken a look at that, and he says, Sir Walter Raleigh was charged with treason, and the person that was with him, this Lord Cobham, had written a statement. He'd gone before what was called the Privy Council, and he gave his statement. So at the time of Raleigh's trial for treason, which of course the penalty was death, they put his statement in, and Raleigh vociferously objected to that. So that is, you need to test him. He is trying to get to gain something from the prosecution, of course, a lesser sentence, right? And courts did not go along with it. But after Rowley was convicted and put to death, the law, a number of people were horrified by what had happened, and the law started to change. So we have this whole, and this is where much of our law comes from, of course, from England and what we call common law. And, so there was a Supreme Court case called Ohio versus Roberts. And as you know, the United States Supreme Court interprets the United States Constitution. And there are very specific words in the Constitution that get interpreted over and over and over. And it seems like it would be cut and dried, but it is not. And so as lawyers and judges, we rely on what the United States Supreme Court says. We rely on what the South Dakota Supreme Court says. And there was a case called Ohio versus Roberts where they have this reliability standard. If it's reliable, you can put the statement in. Well, what's reliable? And you can imagine that would vary depending on the facts. And people were being convicted for these out-of-court statements. So Sir Walter Raleigh knew that what had happened was wrong, and Justice Scalia started with Sir Walter Raleigh's case. And they have quotes from Sir Walter Raleigh. It's hard to imagine that it could be that long. But now it is that they need to be, confrontation has to be face-to-face. There are some exceptions, of course, that apply. And those are, if they're non-testimonial statements. So a person calls 911 and says, help me, I'm being stabbed. All right, so that's not testimonial. Testimonial typically is something said when a law enforcement officer is trying to get information to prove a past crime. If a law enforcement officer is simply getting the information to stop something or an emergent situation, that isn't going to be considered testimony. You can imagine we have cases about this all the time, right? So this is the kind of thing that happens. There was also an interesting case in South Dakota that came out after the Crawford case called Vargas, State v. Vargas. Mr. Vargas was charged with was called attempted fetal homicide. He was married, but he also had a girlfriend on the side, and she was pregnant, and he wanted her to terminate the pregnancy. She refused. So he talked to, I think it was his sister-in-law, and there was something called pennyroyal that could could create a spontaneous abortion. And so he was accused of putting that pennyroyal in her soda and whatever drink she had, and she typically didn't drink it because it was so bitter tasting. So she goes to the police and said, I think Vargas is trying to make me terminate this, or make me have an abortion, a spontaneous abortion, miscarriage. And so the police then, of course, Wipf is probably not all that happy about this baby situation, right? So Wipf agrees to work with the investigator, talks to her husband. I think he was incarcerated at the time, talks to him on the phone and gets him to admit that he had put this pennyroyal in her drink. So then Wipf does not come to trial. She's unavailable. She's subpoenaed, meaning it's an order from the court to require you to come. And so then they want to play that. And the South Dakota Supreme Court said, well, we have marital privilege too. The exception did not apply because if you are trying to either hurt the wife or trying to hurt a child of either of you, and of course it was his child, that exception, the marital privilege doesn't apply. But they did say that Crawford applied, that he is unable to confront and cross-examine the wife over this telephone. So the case got reversed, and that was one of the very first cases I had when I came on the bench. It came back from the Supreme Court, and the decision then was, could he be tried again? And he could, because the Supreme Court remanded it for retrial. And apparently by that point, years had gone by, no witnesses were available, and the state ended up dismissing it. So the other thing I make sure I have to tell people is that, as I mentioned, they have the right for compulsory process, meaning if they want a certain witness to come in, then they say, Judge, I'd like to subpoena so-and-so. I sign the order, and they can require someone to appear in court to testify. So that's an important right for the defendant. Now, they have a right, you've always heard, you have a right to remain silent and a right against self-incrimination. The other thing I advise people, and this of course arises out of the Fifth Amendment, that you can remain silent at trial, you have no obligation to prove your innocence, and neither the state nor the court can comment on that. So there's lots of cases where the prosecution has commented on the failure of the defendant to produce a witness, or sometimes lawyers get worked up and step over the line. Huge violation, because the defendant can sit silent, has to do absolutely nothing, and all the burden is on the prosecution. Now, this only applies to testimonial acts such as speaking, nodding, writing. It does not apply to fingerprints, hair, blood, DNA, things like that. It doesn't go to that. The self-incrimination protects you from being forced to reveal to the police, the judge, the jury, something that might subject you to criminal prosecution. So you've seen people come testify and they take the Fifth Amendment. Well, that's what they're saying. Whatever I'm going to say may possibly incriminate me, and I could be prosecuted for that. So I am going to preserve to myself that important right. I also am required to tell people that they are presumed innocent, and the state must prove their guilt beyond a reasonable doubt. That language does not appear in the Constitution, but our United States Supreme Court has said that these are fundamental rights, and that it's inherent in our Fifth Amendment right to due process. You have a right to a speedy trial, a speedy, impartial, public trial composed of a jury of your peers selected in South Dakota, in the county where you're charged. So this comes up in, when I was in Fall River, Oglala, Dakota County has a large portion of Pine Ridge Indian Reservation there, and the state cannot serve any process to Native Americans on the reservation. There are people that live in that county that are not Native American, and the sheriff could serve them. So we don't have the ability to summon always enough jurors. That's the concern. But we have to try. And so the question is then, could we go ahead and get jurors from nearby Fall River County and try them in Hot Springs? Not in South Dakota. Our Constitution requires that you be tried in the state where the offense was committed, and you're entitled to a jury of your peers. A lot of people complain, those aren't my peers. So there's been a huge case called Batson, is how we refer to it, where the prosecutor, a person of color, was charged with a crime, and the prosecution, during jury selection, struck every African-American person. And the court said that that's a violation of constitutional rights of the defendant. And she can't excuse someone simply because of their race. So now the rule is, if someone excuses what appears to be a particular, perhaps a minority or particular people, you can have a Batson challenge. And they have to come to me, and one side objects, and they come before the court and say, Judge, we think they're excusing all the Native American, the prosecution's excusing the Native American jurors because my client is Native American. Prosecution has to give me an articulable reason why they didn't do it because of race. It doesn't take much, to be honest. They can say they weren't listening. We are aware they have criminal charges pending against them. They fell asleep, and something that you folks probably are very familiar with right now. The other thing that comes, they have the right to address bond in front of me. So typically people come before me, and they might have a very high bond, meaning if they can't pay it, they're going to stay in jail until the trial. And so they ask to reduce it, or they want to change the terms of the bond. And we have a process now in Pennington County that we put as few people on bond with a money bond on as possible, because we don't want them in the jail. We want them out if at all possible. So we try and keep only those people who aren't showing up or who pose a danger to society. We could have other terms of bond that aren't monetary. You have to go to 24/7. Do you know what that is? So if, for example, you have a driving under the influence charge, the magistrate will likely require you to go to 24/7 twice a day so that you can show you're not drinking. If you have a drug charge, you get tested for drugs 2 to 3 times a week at the same place. We call it 24/7. You might have to turn in your passport. You can't leave the jurisdiction. We also have an electronic monitor that people wear on their ankle. And we typically would have an exclusion zone. So if you committed an offense at, sorry you sat in the front row, you guys get picked on. If you committed an offense at Roosevelt Park, I could create an exclusion zone. And if you go into there, I don't know if we have new ones now, but the sheriff's office does. If you go into there, it'll beep, and it'll say, get back, and you get an alert. And so that's a way to keep people out of jail. All right, so now we've gone through this whole process. I've given them their rights. We've set our next hearing. And typically the lawyers will ask me, not all of them, but we want to suppress some evidence, Judge. And that means we think the police collected evidence in an improper way and we want it excluded. And so that's the right under the Fourth Amendment. And we will have a hearing about that. Officers come in and testify in cases where people have been stopped by cars. I watched the video. People will suggest that law enforcement shouldn't have pulled me over. Well, they can pull you over for the most minor of traffic offenses. That you made your left turn too wide, that your back tire touched the white line, that you were drifting, that the license plate in the rear was not illuminated, that you have a headlight out. So they can pull you over for that, and that of course is a seizure because you are stopped. Now, what happens next usually becomes the big question. So there's one question, did you pull me over? Did the law enforcement officer have a specific articulable reason for pulling you over? And as I mentioned, and the United States Supreme Court has supported this, that is fine. So they can ask you questions about your name, which if you give the wrong one, that's a crime. They can ask for your license, your registration. They're going to run a warrant check. They're going to make sure the car is not stolen. All of that should be detained while that happens. They're looking at the VIN number. They also are going to start talking to you. If you're pulled back into the car, they typically take you back to the car. They're going to ask you questions. What are you doing? Where are you going? And when those answers are too vague, or your answers and the answers of the passenger, which this is what happens on the interstate, the driver says we're going to Wisconsin and the passenger says we're going to Oklahoma. Well, so that's a big issue for the police because they realize that's kind of the things people say when they're typically have drugs in the car. And so they use those types of clues to then want to investigate further. They might see that there's a pipe in the car, or that there's bottles on the floor, or rolling papers, and so they're going to want to search at that point. So that's the type, that's called suppression. So I'm going to hear it and I'm going to determine whether someone's constitutional rights were violated. The other thing they do, they challenge on Miranda warnings. So an important case called Miranda versus Arizona required the police, when you have someone in custody, you must give them the Miranda warnings before you ask them any questions. So if you ever watch these videos of the police, and if you're interested, you can do ride-alongs with the police. I've done it, and it was really interesting. But I have to say, the officer kept saying to me, and I'm doing this so I comport with the United States Constitution. Okay, I won't be hearing any of your cases, but you know, they are required to know the Constitution, and they are required to know recent laws that come about. So people might say, I was questioned without being given my Miranda warnings. Well, a lot of times people consent. A lot of times they just blurt things out, and those are spontaneous, and those aren't considered in custody, so we don't need the Miranda warnings. They might also, police will take you in and say you're free to leave, you don't have to stay here. Even though I'm going to close the door for privacy, you're free to go. And it's only when you're genuinely in custody. For example, if you're handcuffed. You could be in custody if there's a lot law enforcement officers, but it's each one is very fact specific. All right, I told you about the right to an attorney. Anytime that the defendant or the person who is subject to arrest says, I want my lawyer, the question has to stop. Has to stop right there. Now, if the police officer just sits there, sometimes people just start talking. But what the police can do is they can come back. I think I've seen as little as 2 hours. They can question them again, but they have to give them Miranda warnings at that time. So the important thing, I think, is that when people are stopped, what they do wrong is they believe that the police are incorrect. So they begin to suggest they're going to assert their rights. And they are resisting arrest, sometimes they're obstructing, and that can result in charges. So the time to contest what's happening is in front of a judge, and rarely with the law enforcement officer. All right. The next time the rights are really significant, your constitutional rights, are when defendants go to trial. I talked to you about the need to have a jury of your peers and how you can challenge some of the people that the state is knocking off. This right to confront witnesses, that happens at trial, that right to cross-examine. The instructions for the jury, I will instruct the jury about the burden of proof, that the burden of proof is beyond a reasonable doubt. That stays with the state, it never leaves. That the defendant is presumed innocent, and that you shouldn't draw any conclusions if the defendant chooses not to testify. I've been very interested in when jurors are questioned, we call it voir dire, meaning to speak the truth. So the whole panel comes in and they're going to be questioned by a little bit by me and by the lawyers. And the lawyers frequently will ask them, why would someone not testify? And because they want to find out, are you a juror is going to say, well, if they were innocent, they would testify. But jurors, potential jurors are very cognizant of how nerve-wracking it would be to testify, that they know they're going to be subject to cross-examination, and most importantly, that they have zero obligation to prove that they're innocent, that the whole burden rests upon the state. So I just appreciate that really important. People are aware of their constitutional rights. A case that you might be interested in, it's called State versus Guthrie, and it's 627 Northwest 2nd 401, that's the site. Happened in the late 90s. A Presbyterian pastor was arrested for drowning his spouse. He had a long-term affair with a woman, didn't want the church to find out about it, and was very unhappy in his marriage. And so he tried a number of ways, including putting like a little wire across the steps to trip her. But it's one of the first cases in the nation where they used computer scientists to go into his computer, his personal one and his work computer, to pull out his searches, and found that he was looking for like accidental drowning, worst medicines for people, things like that. And he learned about a certain drug that could put you to sleep, but it had a lot of side effects. So he goes to the doctor and he says, gosh, I just can't sleep. And so she's going to give him Xanax. No, I can't take that. She's going to give him something else. No, I can't take that. I've heard about this drug. It was like Tazepam, I think. And so the doctor gives it to him. He fills the prescription. He gets 15 tablets. He then tells his wife that he lost it, and could she call and get a new one? So she does, fills that one. Then he somehow or another, he fills it 2 more times. So he has 60 pills. He knows the wife likes to drink chocolate milk before bed, and so the allegations were, and he was ultimately convicted, was that he broke open the tablets and he put 60 of them into her chocolate milk. But he had researched this drug, and so the computer scientists were able to find this. The issue came up that they have a search warrant, but you have to execute these search warrants within a certain period of time. And so the police had waited too long to do it. And, but they went ahead and searched it. Well, it turned out that he put all of his personal belongings in a storage shed, except for his personal computer, which he left with his son-in-law. And when police contacted him, the son-in-law turned it over. The court said that the son-in-law had custody and control of that, and it was within his rights to turn it over. But it's super interesting case. All the what they did to try and learn what had happened, and but really because I think what the computer scientists did. The other time that the Constitution comes into play is when it comes time for me to do sentencing, and so the 8th Amendment prohibits cruel and unusual punishment. That has morphed into more now where prisoners challenge their conditions of confinement. That all kinds of things. I'm not getting medical care. It's just a host of things is how they challenge it. But for me, if I sentence typically within the what the statute provides, it would be very unusual for the Supreme Court to overturn that. I'm required to look at a host of factors before I sentence and make my decision. So I look at how old someone is, their moral character, I look at their history, their mentality, their habits, their tendencies. Do they commit crime? Is this the first time they've ever committed a crime? And so the at that point, if the possible penalty is 15 years in prison and I sentence you to 15 years, it's hard for that to be cruel and unusual, as our legislature has set what that amount is going to be. A fellow by the name of Toavs, T-O-A-V-S, that's also an interesting case. He believed his girlfriend and his best friend were having an affair, so what everybody does, you just shoot them, right? And, so the ultimately went to trial on first-degree manslaughter. The penalty for that is life in prison. He pled guilty, and the judge sentenced him to 2 consecutive terms. So when we sentence, we can sentence you to concurrent, meaning you serve the sentences at the same time, or consecutive, one sentence served right after the other. He sentenced on the first matter 120 years in prison, the second one 100 years, 110 and 100, so 210. He said that's cruel and unusual. That's obviously longer than a life. And the Supreme Court said, no, it's not. And it's not cruel and unusual. Anyway. So that's how the Constitution plays out typically in my work. But it also appears sometimes in civil matters, but I have to say in much, much less. But it does appear. The other thing that Dr. Dreyer talked to me about was how you become a judge. And I quizzed all the judges in our circuit about what their undergraduate degrees were in. And we have a daughter who practices law in Seattle. She's just finished her first year practicing law. And her undergraduate degrees were chemistry and physics. And going to law school was not on her radar initially. But what she likes about the law is you always learn something new. And she really liked that aspect. Because she had STEM degrees, she could, initially what she was interested in was going into patent law. So you have to have a STEM degree to go into patent law, and you're going to have to take a special bar exam. She's not a judge, but I just wanted to show you that there's a lot of different degrees. So here's the degrees from the judges. Communication studies, government and international affairs, natural sciences, biology, chemistry. A lot of people had minors in language. Elementary ed, anthropology, history and political science and French, BS in aeronautical engineering, political science, criminal justice. So political science tends to be a big one for people's start interested in being lawyers. So after you graduate from law school, you're required to take the bar exam, and that is offered twice a year at the end of July and end of February. Once you pass that, you then have to go through a character and fitness review. And your application will include every place you've ever lived. Now, I don't know how it is for engineering or other professions, but I told my kids, one just graduated from med school, I said, please keep a list of every place you've ever lived, every job you've ever had. Because if you choose a profession, they are going to investigate you. And so if you have any gaps, this is gonna come up. And so most people get through the character and fitness, the initial review. I serve on the Board of Bar Examiners in South Dakota, and our job is to grade the essays of the bar exam, but it's also to look at character and fitness. So people get flagged. So if you have a lot of DUIs, if you have crimes of violence, if you are addicted to drugs or alcohol, if you perhaps mental health isn't sufficient, but if it's untreated mental health, that can become a problem. If you have too much debt and you don't have a way to pay for it. Debt alone isn't the problem, it's that if you're not addressing it. All right, so then you get through the character, if you have to have a hearing before the bar examiners to show that you're of good moral character. You get through that, and then you start practicing law. And you can practice law privately for the state. You can be a public defender, work for the government. I worked for a private law firm for a very long time. And then at some point, people come to you and say, gee, have you thought about being a judge? Or you think, I think I'd like to be a judge. So you have to express your interest by filling out, again, super long documents. You have to provide things you've written. They want to know your ability to write. It is really intrusive, but appropriately so in my view. You then, a background check happens where it's usually a retired judge, calls people up and asks them about you. Do a criminal background check. You have to turn over your passwords for any social media accounts and they will look at them. And then you go through what's called judicial qualifications, and this is a panel made up of some judges, lawyers, and one lay person, and they grill you, and then they send 3 to 5 names to the governor, and the governor then chooses how many, if any, to interview. It has happened. The governor has said, nope, I don't like any of those people. But typically then you are interviewed by the governor, and then the governor calls and says, I'd like to appoint you. You can also in South Dakota run. Every 8 years we have to stand for election. Typically no one runs against you, but someone can take out a petition and run against a judge. And then you have to have an election. So that's how you become a judge.
So you were interviewed by the governor?
Yes.
Where was the interview?
In his office in Pierre, and it was really tiny. And I'm not kidding. I was thinking it was going to be this huge deal. And he sits there, and this is Governor Daugaard, and he asks everybody the exact same questions, and he writes down what you say. And so he's not looking at you, and it's a little bit intimidating. And then his Attorney General, I went to law school with him, sat to the right of me, and his chief of staff was to my left, out of my peripheral vision, and then his lawyer was to the left. So who do you answer? And it was pretty thorough, and of course he asked everybody the same question. Well, during judicial qualifications, during that interview, I learned that a concern they had was because my husband was a judge, was that going to be an issue? But of course, given that the governor doesn't ask every person, you know, and you shouldn't ask, how's your spouse going to handle this? Or, although I will tell you that that question was asked of me in 1994. I was interviewed by the governor for a place on the Supreme Court and didn't get that position. But I was asked during judicial qualifications, do you have your husband's permission to do this? And so apparently that question's not asked anymore. So anyway, so the governor and then at the end of it, he said, do you have any questions? And I said, well, I'm wondering, do you have any reservations about the fact my husband's a judge? So I was able to get the question out on the table because he couldn't ask me. And then his lawyer was sitting there, and he had kind of a funny smile on his face, and he knew why I said it. And so there aren't many, there's a couple in Sioux Falls. She was a circuit court judge, and her husband was a magistrate judge. They did a little story about us in the American Bar Association that they thought we might be the only husband-wife appointed by the same governor. That means, but my husband happens to be the presiding judge. That's a position selected by the Chief Justice. It is administrative. We're all constitutional officers, so he has doesn't tell you how to do your job, couldn't and wouldn't. So, so it's just a little bit unusual in our situation. My maiden name is Wipf, W-I-P-F, Jane Wipf Pfeifle, and so the orders that I sign come to me with my full name, but people just say Judge Pfeifle because that's a mouthful, right? So we have the state's attorneys try and keep us separated when they're saying who you appear in front of. They call him he Pfeifle and call me she Pfeifle. And then the deputies who are in charge of our security, they call me Wi-Fi. And so they have revealed that over the years. So they have different ways of referring to us. I get letters from prisoners addressed to Honorable Mrs. Pfeifle. And then one day he got one, Honorable Mr. Pfeifle. I thought, yes. So seems to be evening out a little bit. But any questions for me about anything? Yes, sir.
Have you ever had like a case where someone's accused of stealing something, like jewelry or like clothing or something, and then they come into the courtroom wearing what they
Well, I haven't had that, but it did happen at our law firm. A guy was breaking in and doing very personal things that you would only do in the privacy of your own bedroom. And but he would move things around and hang things on doorknobs. So the police came and they put up some security video, and they saw him, and he was wearing a big sweatshirt with FBI on it. And so couldn't find him, nobody could identify him, and the police are remarkably good about identifying people just by sight, but they had a training for law enforcement officers or reserve officers, see if you wanted to do it, and the guy showed up wearing an FBI sweatshirt. So they take his picture and the video from our office. And so I haven't had that, but yes, sir.
Have you had any cases like involving self-defense with like a weapon? What was your experience with that?
So the most recent case I had was two guys, they were looking for the daughter of a friend, quite young girl, and they thought she was in this house. So they burst into the house and they had knives, and they're, where is she, where is she? And the guy comes out, it was late at night, I don't know what you're talking about, and he, apparently, like everyone, has a machete in his bedroom. So he went and got it, and they won't let him, he's saying leave, and they locked the door, and of course he couldn't get out, that was the only door. I think it was a trailer. It's been a while. But anyway, so at some point the guy with the machete cuts the guy. He doesn't die, but of course he's severely injured. But his argument was that was self-defense, that I had to stab at him because of that. The jury didn't buy it. He broke into the house, he brought the evil, he brought the knife. So, but yeah. Another time they had a big fight over, two guys got really drunk and fought over who had the better motorcycle. That apparently was super important. And so the guy with perceived to have the less good motorcycle went to punch the other guy, and I don't know, huge big fight. And there was some question of self-defense, but really, do you defend yourself against a slur against your motorcycle? So, yeah. So, I mean, the jury hears all this, and it's the jury who makes the decision at that point, not me. So, I'll stick around for a couple minutes if you have a question you don't want to ask, but you've been very interesting to talk to. Thanks for hearing me, and thanks for supporting your Constitution.